And our final panelist today, and for the formal panel presentations, is Alex Tallchief Skibine. Professor Skibine is a teacher of administrative law, legislative process, torts, and federal Indian law. He received his BA from Tufts and his JD from Northwestern University. Prior to joining the University of Utah's faculty in 1989 as a law professor, he served as deputy counsel for the Indian Affairs Committee of the Interior and Insular Affairs Committee of the U.S. House of Representatives. Did I get that right? Okay, the Interior and Insular Affairs Committee. He is currently the S.J. Quiney Professor of Law at the University of Utah's S.J. Quiney College of Law. He is the author of a number of articles on American Indian law, including articles on Indian sovereignty, Indian gaming, as well as having presented testimony before Congress on various Indian-related issues, both prior to his incarnation as a law professor and during his incarnation. I'll tell a story on Alex because he and I go back quite a ways, but he has his fingers in many of the legislative statutes that's been adopted over the last 20 years. Since the time he worked on the committee as one of the counsel for the committee, as well as since then. So help me welcome Professor Skibine as he presents his paper, Cultural Talk in Federal Indian Law, Defining the Terms, the Debate, and the Meaning of Native Culture. Alex?
Thank you. Thank you. That title sounds a little bit presumptuous. Anyway, as Bill said, I wrote on Indian gaming and political issues. He didn't mention Indian culture. And the fact is that I've been, in a law professor for 20 years, but I've never really written on Indian culture. So the question that you have is, what is this guy doing here? And Bill basically revealed yesterday at dinner that I'm the token male on the panel because most of our most prestigious law professors are all women, and you heard two of them on this panel. Angela Riley and Rebecca Tsosi are the two others. Those four women together have written most of the most important thing on Indian law. But fortunately, I had the chance to review Kristen Carpenter's work for her tenure, so I read all of her stuff, and that's all I know about Indian culture, cultural rights, so blame her if I make any mistakes. Anyway, the question that so who am I? And one of the problems is that Kristen asked me at lunch. She said, "So, are you from Oklahoma?" And I wanted to look at her, and I wanted to say, "Don't you recognize a Osage reservation accent when you hear one?" And but the fact is that I am an Osage from France, and but my connection with Indian culture goes a long way. As a matter of fact, I spent a year on the Osage reservation when I was a child, and I remember meeting my great-grandmother, and her name was Eliza Bigheart, and so she had culture, and so I spent a year there, and I remember when I was reminiscing about her with my aunt Maria Tallchief, the famous Osage ballerina. She said, "Yeah, my grandmother, your great-grandmother, Eliza Bigheart, she was a real blanket Indian." Yeah, and I kind of looked and I thought, is that politically correct to say? And so I remember meeting this woman. In fact, it was about just right now, 50 years ago. And the Osage Reservation then was a different place. I remember that all of the public functions of the tribe, what's a marriage, a funeral, if you're going to speak publicly, you had to speak in Osage. That was the rule 50 years ago. And I remember coming from France, and my father is Russian, so I grew up listening to Russian and French, and I remember hearing those Osage talk, and I remember thinking, God, this Osage language, sounds a heck of a lot more like Russian than it does English or French. But anyway, so back to the blanket Indian. So was Maria politically correct? And of course, so I did some research, and I found out that in effect, during the allotment era, so my great grandmother, in effect, that was her youth, 1900 to 1920, and that wearing a blanket for Osages was basically a sign of cultural resistance, that you were going to remain an Indian, a cultural Indian, and were not buying into the assimilation policy of the allotment era. So I should have known better than to question my Aunt Maria's use of the term, but it was obviously not a pejorative term in her mind. So that was my first exposure to Indian culture. And then, as Bill said, I went to Capitol Hill, and I was the Deputy Counsel for Indian Affairs for Morris Udall between 1980 and 1990. And so I want to talk a little bit about what I did there. And it took me 9 years to get around to start looking at cultural issues. And but what did start the thing was first in 1988. The Ling versus Northwest Cemetery decision came down. And for some of you that are not lawyers, that was a pretty depressing decision from an Indian perspective, because in effect the Supreme Court said that when it came to protection of sacred site, Native practitioners could not use American constitutional law to have their rights protected. So that kind of got me started to thinking, maybe that should be repealed. That particular decision should be overturned. So I started working with the Native American Rights Fund, and I think Steve Moore was one of the major counsel there. And I prepared a bill for introduction for Morris Udall that in effect would overturn the Ling decision and reinstate what we called the strict scrutiny test whenever anybody interferes with the Native religious practitioners, freedom of religion. And so this bill was introduced, and at the same time, that same year, those were my last years on the committee. We had just finished Indian gaming, and I guess I wanted to go I felt kind of sinful. So I wanted to go from being a sinner to the sacred, and that's why maybe I turned to looking at troubled cultural issues. And at the same time, there was a Canadian woman that had asked of the Smithsonian to go and look at certain artifacts that the Smithsonian had. And they were Indian women's bag. And she was an artist, and she said, we have lost the last of those bags, and I'm trying to revive my culture here in Canada, so I want to look at the Smithsonian had the last remaining bags of this particular era, and she wanted to recopy the design so then she could start making those women's bag. And the Smithsonian basically said, well, I'm sorry, you can't go in there because it's totally infested with asbestos, and it would endanger your health. So then she somehow wrote our committee, Morris Udall, and I got to answer her letter, and I said, that cannot be true. So I called the Smithsonian. In those days, the Smithsonian were not that friendly, as you'll find out, to Indians. And I said, can't you get this woman to see the last remaining example of this traditional culture of making women's bag? And she said, no, you can't. So then I got mad. And I wrote a letter on behalf of Morris Udall, so he signs it, and basically saying, we understand that you cannot give access to Native women to look at some of the artifacts because of the asbestos program. We're going to have an oversight on that because we think, because basically was the Committee of Jurisdiction, we think that there is a huge health problem, obviously, with the asbestos. Immediately they called me back, oh, you can come in, you can come in, you can come in. So we went down there. And it's true there was asbestos, and we had to put masks. And so we went in there, on the Smithsonian, there were like there's 8 sub-basements. So we go into one of those basements, and there was there's native art and artifacts, like there were canoes that were as big as this stage, stacked, ceiling high. This was basically there were thousands and thousands of those native artifacts and objects in the Smithsonian basements. And then, you start opening the drawers, and this was the way that Rebecca Tsosi and Angela Riley had mentioned. In effect, you look, and there were bones in there, like native. At that time, the Smithsonian had over 32,000 or something like that of native remains, skeletal remains, but just native, not other people. And so at the same time, I was working with Walter Echohawk of the Native American Rights Fund, who had basically been a trailblazer as far as respecting native remains, burial grounds. And after I saw that, I thought, well, something has to be done here. And so I worked on a bill, and I got Mo Udall to introduce a bill that in effect would force the Smithsonian to repatriate all human remains that belong to, that were Native American human remains, and that they had. So there were those 2 bills, for that year, 1988, 1989, and I thought I was going to have an easy time, and certainly we didn't have an easy time passing the gaming bill, but we did. So I thought, we're going to have an easier time doing this. I was wrong. In effect, the law has not been favorable to native culture and cultural rights. So let me talk to you about the first bill, overturning Ling, and so that the sacred site could be protected. We had a hearing, and suddenly all of the major energy corporations in the West showed up at the hearing, and I was totally surprised. But they were all represented, and in effect they were saying, oh, if you allow this to happen, they're going to paralyze the whole federal landscape. There wouldn't be any more timbering, mining, or anything like this. And so I know, basically, there was no dialogue that was possible with those people, and the bill died. When it came to the human remains at the Smithsonian, in effect, the Smithsonian fought us extremely hard on this bill. And it was not going anywhere. I mean, we had meetings. Unlike the corporations, they were willing to talk to us, but they were extremely opposed, claiming that, this was absolutely necessary for all of this kind of research. And so the bill was dying. It was not going to go anywhere. And suddenly, I saw on the Senate side a bill that everybody loved, the National Museum of the American Indian bill. This was sexy, and all of the non-Indian interests loved that bill. But they didn't like my human remains bill. So when finally it passed the Senate, and it was, really, and McCain were there, it came to our committee. And I thought, well, they all want the Museum of the American Indian, so let's attach the human remains bill as Title II. So in the committee, we attached that in our committee, and of course it passed. Because, but without the Museum of the American Indian bill, that particular, the reason I mentioned that particular bill is because in effect it became the precursor to NAGPRA, the Native American Grave Repatriation Protection Act. It wouldn't have passed at that time. And of course, then NAGPRA passed in 1990, a year or two later. All right, so that's my background and what they did on Capitol Hill. The third thing I want to talk about is this, the question of law and culture. And, who should set the term of the debates when we talk about law and culture, and who should define native culture. So here I have there's one more story that I have to tell about law and culture. About 5 or 7 years ago, I think, Suzanne Harjo arranged some kind of a cultural retreat where she brought together in the Black Hills a bunch of tribal cultural officers, people that work for tribes in charge of preserving tribal culture. And then she had a bunch of tribal attorneys, and I guess I was representing legal academia. So we were, and we were all the tribal attorneys were either Indian attorneys or non-Indian working as tribal attorneys. They were all pro-Indian. So we sat down, and there was a huge amount of ice breaking to do, because in effect the question was the tribal cultural officers were extremely intimidated by the language of the law and the legal terminology. So the question was, who was going to define the terms of the debate? And they were, in effect, they didn't trust us. They didn't trust the lawyers in the room, because in effect they said, maybe law and culture is like oil and water. It just doesn't mix. So it's our culture, and do you want to impose your law on us? Can we really talk about cultural rights in terms of the law? Keep in mind that, in effect, the history has not been great as far as Indian culture and legal protection. So we had, it was interesting because, in effect, we had to break that ice. And all I can tell you is thank God for Walter Eckerhawk. I think some of you, may know him, but he was one of the tribal attorneys, and he was able to bridge the language barrier, so to speak, so that we could actually have a very good exchange of ideas eventually. But it was pretty rough. So then that made me think, when we talk about law and culture, what is the debate about? Okay, and we have to be very careful, as lawyers, how we phrase the debate, because the culture folks, the tribal people that live out there don't trust the law. So, and they don't, so the question is, how do we phrase a debate? So there's three things that I want to talk about. One is, do we talk in terms of religious or cultural rights? Okay. Number two, do we talk in terms of individual rights, or cultural rights? And number three, do we talk in terms of political rights or cultural rights? Okay. So here, when it comes to religion, is there a difference between religion and culture? Sometimes people think that it's pretty hard to say when it comes to Native Americans, but it's hard to say for everybody. I remember one of the professors at my school is Israeli, and he was talking about the wearing of the veil for Muslim women. And he talked in terms of completely religious idea for him. And so then I was listening to a show on NPR about American Muslim women. And when they talked about the veil, they talked mostly in terms of cultural rights, not that much in terms of religion. So sometimes it's hard to tell them apart, but there is a couple of fundamental differences. First, culture can change. Religion usually does not. Secondly, in effect, culture can be negotiated. Religion usually cannot. I mean, this is why, when I was on Capitol Hill, we could never resolve the Navajo-Hopi land dispute to everyone's satisfaction. Because, in effect, the land was sacred to the Hopis, and that same land had become sacred to the Navajos, for different reasons, but it was sacred. They both thought that this land was sacred to them. So ultimately, I think that's an important difference when you look at cultural rights versus religious right. Number two, property versus fundamental rights. Is treating cultural rights as property right a bad idea, for instance, because property has a tendency to be commodified or commercialized? My co-panelist, Kristen Carpenter, recently published, along with Angela Riley, this great article in the Yale Law Journal. And I think it represents a very good idea of how to do this and avoid the pitfalls. Instead of trying to fit Native American cultural right into conventional property rights, she redefines what property rights should mean so that Native rights can be respected. In other words, she does not change Native cultural rights so that they can fit into traditional property rights that are Western concept. She basically changed the meaning of property so that it can fit within Native cultural rights. And it was a pretty smart move. And the question is, can this be done with other type of field? So for instance, if we want to talk about fundamental rights, do you want to fit cultural rights into some fundamental rights like religious rights or or other rights, or do you want to create maybe a new fundamental right, like I said, to cultural identity? Okay? The Columbia Constitution of 1990 recognized the right to cultural identity as a fundamental constitutional right. So ultimately, it's not that far-fetched of an idea. The third thing is when we talk about political versus cultural rights. Here, the question is, should we talk about cultural sovereignty, like Rebecca Tsosi talked about this morning, or political sovereignty? And, political sovereignty has some baggage, and usually it means confrontation, political rights. I have jurisdiction, you do not. So maybe, I think Rebecca's idea is a very interesting one. And that maybe it's better to go this way, to talk in terms of cultural sovereignty. However, there are some pitfalls. And in a thoughtful and insightful essay, Sam Deloria once made the following comments. I don't know if some of you know Sam Deloria, but he has a pretty sarcastic and interesting way of putting things. I'm going to quote him at length because I think it's worth it, and I cannot replicate the sarcasm or the funny way he says it, so bear with me. Let me warn you about something about this cultural business in the law of the United States, which is the way decisions are made and power allocate. That power can put us, Native Americans, out of business. Our existence is on a thread. In the law of the United States, we are entitled to self-government because we, as society, pre-existed this government that came along. And that's fine. This is an abstract, theoretical base for our tribal existence. And there are no conditions on that. If we stake out a position that said that our right to tribal self-government is tied to our dedication, our adherence to culture, we're saying for the first time, we, capital, are saying it's conditional. So we better be damned careful that we're not saying to this society, in exchange for a continued political existence, we promise to maintain some kind of cultural purity. Because you think it's going to be by their standard, by our standards? Hell no, it's going to be by their standard. In other words, they are going to define what cultural sovereignty means to you. So, I think this statement, I think is very meaningful, and there's a lot of things that you can say, but it did bring to mind this idea of in the domain of culture, that we can negotiate culture up to a point, but it's very important that the native population retain control of the terms of the debate. So no one is arguing here that there is a static, traditional Indian definition of what is Indian culture. In an insightful article, Cherokee scholar Alan Ray made the argument that the concept of cultural hybridity, which I think Kristen Carpenter mentioned, this concept has played a large role in the evolution of Indian culture, and especially Cherokee culture. He then cited the work of another theorist, and so then he writes that cultural hybridity are those moments when the scenario written by colonialism is given a performance by the native that estranges and undermines the colonial script. The same argument was made by Bosch and Anderson concerning tribal self-government. And they said tribal self-government should not be identical with cultural fossilization. While self-government does not depend upon the pioneer culture, self-government transcends culture. It is the right to choose culture. And then we all have cultural hybridity in some ways. It doesn't mean that we're not Indians. Most of the people that are Indian in this room have made some compromises. For instance, look at my name, my middle name, Tall Chief. There was an Indian way of saying it before. That was the first compromise. And then when my Aunt Maria Tall Chief went from, she was a reservation Indian until she was 14, and then she went to Berkeley, to Beverly Hills to basically get serious about her dancing career in high school, and she got immediately teased. Maria Tall Chief? So is Tall your middle name, and is Chief your last name? Should we call you Chief? So she's not going to take any, she was not, so that's it. She said, we should change our name. And this is why our name from Tall Chief became Tall Chief, one word, because she was annoyed at the way people were teasing her mercilessly in Beverly Hills High School for this, the way, to write her last name as Chief. So we all change things, but we still should be in control. So that's the last thing I want to talk about is the 4 areas of cultural religious concerns that are out there, and basically try to figure out what is at stake for Indians, and looking how the law has treated those 4 areas, and try to derive some kind of reasoning concerning this. So there's 4 areas. The first area is peyote. The second area is eagle feathers. The third area is NACPRA and the Bonnickson man controversy, and the fourth area is sacred sites. And basically, I arranged them in that order because, in effect, the dominant culture has treated peyote the best and sacred site the worst. So in peyote, in effect, the dominant society has accommodated the religious practices of Native Americans. So that's the one area, in effect, that we have, in 1994, Congress amended the American Indian Religious Freedom Act that basically said states could no longer prosecute Native Americans practicing traditional religion using peyote. When it comes to eagle feathers, there has also been some accommodation made by the dominant society. But one of the themes that that is in the article that I will eventually write is that in making those accommodations, is the dominant society in effect influencing the definition of culture or influencing Indian culture? Okay, so you can choose the terms of the debate, or then we can look at specific area. And when it comes to eagle feathers, in effect, the answer is yes. Native Americans can get eagle feathers for religious practice, but they have to go through a very intricate permit process. And in effect, the courts have refused to uphold the right of Native American outside the perimeters of this very rigorous permit system. So this, in effect, reflects a judicial willingness to strongly defer to the executive or legislative branch in this area. I think it also exemplifies one other thing, and is what some scholars have said is the court's hands-off approach to free exercise of religion cases. And I think that's important. It's going to become important in other cases too. All right. So this is eagle feathers. The third one that I want to focus about is NACPRA and the Bonnickson controversy. Because here, again, NACPRA is, along with the Indian Child Welfare Act, perhaps the most pro-Indian legislation that Congress ever enacted. But there are some issues with NACPRA. Again, Indians have to redefine their rights to fit under that federal scheme. Okay? And I think that can take a toll, and it can also allow the dominant society to influence the meaning of Native culture. The Bonnickson decision, this is the famous decision that the 9,000-year-old man could not possibly be related to Indian culture. Okay? There's a lot of things that have been written about it. My co-panelist, Alison Dusias, wrote a book-length article on this issue, and so did Angela Riley and Rebecca Tsosi. So what can I add? And I have to tread lightly here in front of the experts. There are a lot of important things about this decision from my perspective. One, from a cultural perspective. This has to do with what I call cultural continuity and who can claim the past. So in effect, it has a lot to do with the legitimacy of the tribe's claim that they should have special rights because, in effect, they were here first. Underlying the Bonnickson court's decision is the position that, in effect, Native Americans were not here first. That, in effect, the continent was settled by people who had nothing to do with Native Americans. In effect, it is nothing short of an attempt to say that this was not native land to start with. And I think so. As a result, it's a huge attack on troubled culture. Now, it's only a decision of one circuit, the Ninth Circuit, but it's still a meaningful decision. You know, one thing that comes to mind about this decision is this: if not then, when? Okay? If 9,000 years ago these people were not culturally Indian, when did that Indian business begin? The court never answers this question. It basically says that no tribe could possibly trace their culture back to 5,000 years. So one of the things that this reminded me of there was some Harvard geologist and chemist that did an analysis of the Sphinx in Egypt. And he basically said, you know, people thought that the Sphinx was 4,500 years old. But in effect, my test revealed that the Sphinx may be 9,000 years old. The same age as the Bonnickson man, okay? And so then I went to Egypt, you know, on the law school fund. No, I'm just kidding. I went to Egypt and I talked. There was a young Egyptologist, you know, a young guy, and I asked him that question. So, you know, how about this Harvard PhD guy that claims that geologically, you know, the Sphinx may be 9,000 years old? And he looked at me and said, well, that would cause a huge problem for us, because in effect, even Egyptians cannot trace their culture more than 5,000 years before Christ. Okay? And so as a result, what the Western world, the Harvard PhD is telling us, that in effect, the Sphinx is not Egyptian. You know, this is what we based our culture on. So we can't do that because we cannot trace it this far. But you know, they'll be damned. They're going to claim the Sphinx and the pyramids anyway, right? So here, the court in Bonnickson did the same thing. The court said, well, nobody can, he said, those Indians cannot trace their cultural heritage past 5,000 years before Christ. You know, and the fact is, nobody can. Something really weird must have happened about 5,000 years before Christ. You know, no, really, I'm serious. A lot of people think that this is when actually there's some huge floods of biblical proportions. So that's one thing I thought about. The second one is this idea that of you know, cultural continuity. And it's important to Indian people, but it's important to everybody. It's certainly very important to the French. Okay, so the French, for instance, you know, like when you go to France, one of the things they say here is our ancestor, the Gauls, you know, Gauls. But in effect, the Gauls are not their ancestors. The Franks were a Germanic tribe that invaded a country that was originally inhabited by Celtic tribes, or Gaelic tribes. And those guys were reputed to be barbarians that were fierce warriors. Sounds familiar, you know, but in effect, what is important here is that nobody in France identifies as being a member of those Celtic tribe. And the French are now saying, our ancestor, the Gauls. In effect, they're not Gaul, they're not Celtic, they're Germanic. And so the interesting thing is then they claim that all of that culture, you know, those rock cultures, this is called dolmens and menhirs, they're all French, you know. You have to be I think Native Americans have to be very careful that the dominant society does not start talking about our ancestor, the Indians, because then you may have lost the war there. So ultimately, that's one of the reasons why Bonnickson is an important thing. Secondly, from a religious perspective, many tribes, their religion said that they were the first people in a given area. And in many cases, the Creator, in effect, told the tribes to take care of that area. That's why, you know, that's the Hopi religion. So, you know, when we were trying to settle a Navajo-Hopi dispute, we told the Hopis, hey, I tell you what, why don't you concede this area to the Navajos, and instead we'll give you this land, you know, further south. And they looked at us like, but the Creator did not tell to take care of this land. He told us to take care of that land. So ultimately, is this peculiar to the tribes? No, it's not. I mean, if you are a Christian or a Jew and you have read the Old Testament, you know that that is the basis of the covenant entered between God and the Israelites when they came to Palestine. it's basically a God telling you. So see, everybody seems to be able to understand that concept when it came to the Israeli conflict, but somehow there's a disconnect with Indian land, and they don't seem to understand that. So finally, let me. The last thing about Bonnickson that is important is that who should define who is culturally Indian? And the holding of the case, in effect, may tend to prove Sam the lawyer right, when he warned us that it is going to be by their rules that you're going to, at their standards, that you're going to define what is Indian culture or who is an Indian. Because in effect, this guy said, this man could not possibly be culturally related to an Indian. So it is a huge thing. Finally, and this is the last thing I'll mention, when it comes to protection of sacred sites, again, when I did that bill for Udall, I got blindsided by the incredible venomous attack from the energy corporations. And so there's a problem with sacred sites. Again, there is, and I don't see an easy solution. I think that the way the religion is now, it seems that this court has a hands-off approach to religion. What this means is that they are defining, a substantial burden on religious rights in such a narrow way that in effect Indians cannot take advantage of of a potential constitutional right. And I'm not going to go into and bore you with the fine distinction of how do you describe substantial burden. I'm just going to leave you with this. We have to be careful here that the courts do not develop legal principles that in their application can in effect only hurt Native American religious interests. Philip Freaky, the great professor at Berkeley, wrote an article where he described how the current Supreme Court has abandoned Native American exceptionalism of the Marshall Court, the Marshall Trilogy, and is in the process of mainstreaming Indian law into the rest of public law. And he sees only bad things happening from that. This would be bad enough, but I have a worse scenario. The court may be in the process of inventing its own virulent brand of exceptionalism in Indian law, where it formulates principles that pretend to follow general theory of public law, but in fact are only adversely affecting Indian cultural interest. And if you doubt this, some of you that are lawyers in the room, reread City of Sherrill. If you look at City of Sherrill, this is a case that basically got rid of all Indian land claims in the East. In effect, the principle can only be applicable to against Native interests, even though they talked about in terms of the latches and other kind of equitable doctrines. The same thing could be with the sacred site protection. The court seems to say, well, those are general principles applicable to everybody, but in effect, they only work detrimentally to Indian cultural interest. I'm past my bedtime. You have been very patient. Thank you very much.